Aye.
Good morning. Please be seated. Good morning, folks on the telephone. This is Judge Mahoney speaking. We're here in the Chapter 13 case of Karen J. Anthony, bankruptcy 11-42232. Today's hearing concerns objection to exemptions filed by creditor Cattle National Bank and Trust Co. The debtor has resisted. Appearance, please, for the debtor. Ms. Anthony, are you there?
Yes, Your Honor, I am.
Thank you. And you are without counsel, is that correct?
That is correct.
Thank you. Appearance on behalf of the bank.
Your Honor, John Guthrie on behalf of the bank.
Thank you. Mr. Molnar, are you there?
I am, Your Honor.
And who do you represent, sir?
Your Honor, I represent Edenton North Homeowners Association. I do not intend to participate in here. I was only curious as of its outcome as an interested party.
That's fine. Is there anybody else on the phone? Okay. Take that as
Your Honor, this is Karen
Yes.
Anthony. Would it be possible for me to ask a couple of questions for my own clarification before we begin?
Well, it's unusual, but I'll permit it. Go ahead.
Thank you, sir. Are we now on record?
Yes, ma'am.
I appreciate your time this morning in considering these motions. I do need some clarification on two issues. As of 9 a.m. this morning, Cattle National Bank has apparently not filed a proof of claim with the court. Is that correct?
I don't know.
It is my understanding that if a creditor does not file a proof of claim, they do not have standing in the bankruptcy court. Could you please provide a judicial ruling on that specific matter?
That is not necessarily correct. If they don't file a proof of claim, they may not be allowed a distribution from the Chapter 13 trustee, but that doesn't mean they don't have standing if they're a creditor.
So then that's what I would like to have a ruling on. Does Cattle National Bank have standing to make any kind of a motion when they have not filed a proof of claim?
Yes.
Because I right now would object to their having standing in this court.
Well, you are incorrect. They have standing. We shall proceed. Mr. Guthrie.
Your Honor, on the motion objection to the exemptions, I'd ask the court to take judicial notice of a certified copy of the deed of trust filing number 80.
Your Honor, I cannot hear anything that's being said by Mr. Guthrie.
Why don't you stay seated, Mr. Guthrie?
All right.
Okay, he'll pull the mic up and he'll say it again.
All right. Excuse me, Ms. Anthony. In support of the objection to the exemptions, I'm offering the certified copy of the deed of trust, which is filed at the bankruptcy court, filing number 80.
Do you have any objection to filing number 80?
I do, Your Honor.
And what is that objection?
Your Honor, I am not there to witness it, to take a look at it. It's a copy of something I cannot verify. I was under the understanding that this was going to be an informal hearing. I'm a little puzzled as to why Mr. Guthrie might be there. I could have easily come down to the hearing, and at this point I would request a continuance so that I could come down to the hearing.
Denied. You were told in two different orders in the last month that these hearings would be telephone hearings, non-evidentiary as far as witnesses were concerned, but that you were perfectly capable of and invited to join us at the courthouse if you wanted to. You have chosen not to. You're not going to get a continuance based on that. You have received through the system or the mail from either the court or Mr. Guthrie's office a copy of the deed of trust. You have participated in a deposition concerning it. You can make a specific objection if you want to, but having not seen it is not going to be a good enough objection. Do you have a specific objection to the admission of the deed of trust?
Your Honor, I object. It's not a document.
It's not what?
An original document. It's a copy that cannot be verified.
the objection is overruled.
I would ask the court to take judicial notice of the Schedule B, the amended Schedule B, filing number 58, and Schedule C, filing number 58, filed by the debtor.
I'll take judicial notice of Schedules B, filing 58, and Schedule C, filing 58, filed by the debtor.
And I'd ask the court to take judicial notice of Schedules A, B, and D, the original filings by the debtor, filing number 13.
I'll take such notice.
I have no further evidence to offer.
Tell me what the objection is.
Your Honor,
Just stay seated.
The objections are really on three issues, but primarily two. First, it's to clarify for Ms. Anthony in the court record on the homestead exemption. We've objected to the exemption claim to $60,000 to the extent she intends that to apply to the banks because the bank has a claim visa its deed of trust, not only by statute 40-103 of the Nebraska statutes, which recognizes that acknowledged deed of trust as waiving that homestead exemption, but also at paragraph 26 of the certified deed of trust, the debtor, Ms. Anthony, waived that homestead exemption. So normally this wouldn't come up, but I just wanted to make the record so that there's not misunderstanding on the debtor's part that the homestead exemption, by not objecting, is not to, we don't take that as to apply to a mortgage lien granted to the bank by its deed of trust. So that's the first part. The second part was dealt with an exemption claim of $12,400 for personal property. As the trustee had filed, there's also an objection because it wasn't clarified what was being itemized. Ms. Anthony's filed an amendment to that, and I don't really have much concern about the $12,400 part. The other one is to a $2,400 claim of exemption, Your Honor, for tools of the trade. I can't figure out what those tools of the trade are, nor if it's what totals the $2,400. It's potentially there's some inventory that's in her schedules for $550. There's an interest in a vehicle she owns at $800. I don't know if those are the two tools of the trade, but I don't get to $2,400. So it wasn't clear as to what she was claiming, nor the valuation she got to based on the schedules that have been filed, Your Honor.
All right, thank you. Ms. Anthony, let's take that in reverse order. What are you claiming as tools of the trade, and what are the values?
Your Honor, I have two automobiles, for lack of a better word, in my garage. One of them is partially owned by my daughter. One of them is a 1995 Chrysler van that is owned by myself. Those are the two vehicles that are listed as tools of the trade, along with some inventory for a company that I'm a distributor for.
And have you identified on the schedules any place the vehicles and their values?
I did. I don't have my schedules in front of me, Your Honor.
Your Honor, she did identify the one that she owned, the vehicle. She identified the value at $800, and she identified the inventory at $550.
Okay. So how do we get to $2,400, Ms. Anthony?
I put in both of the automobiles because right now I'm using the Volvo. When my daughter graduates, that car will probably become hers for her sole use.
Is it titled in your name at this time?
Right now it is, but it's going to be jointly titled because she actually owns about 2/3 of the current value of that automobile.
Okay. And do the schedules show the value of that automobile?
They show an approximate value, Your Honor.
Okay. So do the two vehicles together and the inventory add up to $2,400?
I think $2,350.
Okay. All right. With regard to that portion of the objection dealing with the $12,400 or $500, whichever it was, and with regard to the objection to the tools of the trade, those portions of the objection are denied, and the exemptions are allowed. Ms. Anthony, now you may respond to Mr. Guthrie's position that you have waived, by the execution of the deed of trust, a homestead exemption with regard to the bank's interest, or that the statute itself provides for a waiver.
Thank you, Your Honor. There's a couple of things I would like to address. With respect to the deed of trust, if that is an accurate copy of the deed of trust, and I obviously cannot confirm whether it is or not. There are two addresses listed on that deed of trust. One is the current address that I'm sitting at right now, 4930 Thomas Brickworth Lane. The other address is 7400 Glen Oaks Drive. Now, I am not only a pro se in this bankruptcy hearing and learning as I'm going, and I apologize for the problems that causes to you, but I'm also not a person who's experienced in the whole process of buying a home and executing those kinds of documents. I have been told, and I'm planning on having an audit done on my financial statements. That deed of trust should have been rewritten. That deed of trust right now is inaccurate and, to be honest, fraudulent, because it lists two addresses and the bank has no interest in that other home, and that deed of trust should have been rewritten, re-executed by the bank when that other home was sold and the equity that was in that home paid down that deed of trust. And that did not happen. So I do object to the amount of $285,000. It is not accurate. And what's more, the other problem here is finding an accurate sales price for this home, because until the bank provides a proof of claim stating how much I supposedly owe them, there can't be any value set on that. There really can't be any realistic value set on the house, actually probably until it's sold or until a market analysis is done, and that has not been done yet. So it's really hard to say whether I would have a $60,000 exemption or not, Your Honor.
Well, the issue as to whether or not you are eligible for a homestead exemption of $60,000 doesn't have anything to do with what the real value of the property is right now. The question is, as has been brought forward by Mr. Guthrie, no matter what the value of the property is, do you have a right to a $60,000 homestead exemption or an exemption of any amount? And his position is you have waived that. So your argument is not relevant with regard to the issue that's before the court.
Your Honor, if that document is fraudulent, then it is void from its inception. And if it's fraudulent and void, then they have no reason to object to my $60,000 homestead exemption. If that document that they've entered is fraudulent, then they have no argument against me.
You use fraudulent as an interesting term. What do you mean, fraudulent? How is it fraudulent?
That document is, as I understand it, it can be a securitized document and it can be sold. And in all likelihood, financial institutions do sell them. And in this whole transaction, what I am trying to get to the bottom of is whether or not Cattle National Bank put up anything of valuable consideration in this transaction. I believe that they have not. I've had difficulty getting a hearing in court so that I can ask them to bring forth evidence that would support my stance.
Were you able to pay for the construction of the house?
There is a house here, Your Honor.
And was it financed by the bank?
I don't believe it was, no.
Who financed it?
The bank was involved. I don't believe that they put up any money. I believe that my promissory note is what financed this house.
Your promissory note is money?
I don't know what money is anymore, Your Honor.
Okay.
What does the court use as a definition for?
Well, we're dancing around interesting tunes, but you know as well as I do that you couldn't take a promissory note to the grocery store and buy groceries with it. You have to have silver certificates or a check that's represented by a bank account or a credit card. So why are we playing this game?
It's not a game, Your Honor.
It sure sounds like it.
Promissory notes can be sold in the securitized market, and they are sold.
That hasn't got anything to do with whether you received funds that enabled you to build a house or buy a house.
Sir, Honor, that's what I am trying to get to the bottom of in requesting a hearing, to have the bank bring forth proof that they actually did provide any kind of valuable consideration for this home.
If they didn't, who did?
That's what I'm trying to find out, Your Honor.
You're pressing it. You've got some advice from somebody that doesn't know what they're talking about, I'll tell you that. But let's move on. I'll deal with the, I'll deal with it right now. There's a deed of trust in evidence at this time. It has a term of waiver by you of your homestead exemption until and unless you are successful in objecting to their claim, if ever filed, or successful in the adversary proceeding. And until that time, you do not have a right to a homestead exemption in this case. Now, if you are successful in an objection to a claim, if it's ever filed, or if you are successful in the adversary proceeding, avoiding or voiding the lien, then you will have a right to a homestead exemption. But until that time, you do not. And so I will sustain the objection to the homestead exemption for now. Now, let's move on to the next matter, which is in the adversary proceeding of Anthony versus Cattle National Bank, adversary proceeding 11.